to you. Bill Witt and Tara Kendrick. They are with Senior Resource Center. They'll be providing our presentation today. I believe Stacy Berry is also here. And I'm going to let them tell you about themselves and the expertise they're bringing to the presentation. And with that said, I'm going to turn it over to Tara, and she's going to talk a little bit about Senior Resource Center. And then I believe Bill's going to lead us through the actual material. So Tara, take it away. You might be muted. We might be having, I think we're having some technical difficulties, Tara. I'm actually looking at.
Can you hear us now?
I can hear you, but I'm not seeing your presentation. It went away.
Okay, so now I need to go back at the presentation. Yeah, somehow we got muted. So there we go. All right, we're good.
Awesome. Here's Tara.
Hey. All right. Hey, everybody. Thanks so much for joining us today. Just to kind of give you a brief overview, we help in 4 different ways at Senior Resource Center. So we do comprehensive retirement planning. So what that looks like is someone may come to us and say, hey, I'm worried I'm going to run out of money before I die. And so we do a 20 and 30 year lookout with our really great retirement software and kind of see where they are and what tweaks they can make to make sure that they don't outlive their funds. We also do tax planning. So we're not CPAs, but we just help try to find ways to pay less tax in retirement. We do a lot of long-term care planning. So that can mean helping people to qualify for federal and state programs through the VA or through Medicaid, or helping people move and plan their assets to make sure they can pay for long-term care. And then we do estate planning. So making sure that people have their estate in line to get their wishes met now or when they pass. And so that's kind of what we're going to be talking about today. But something you may be interested in, and this will be part of our SRC University, is we created this little program called SRC University, and they're just little retirement education sessions. They're about 30 minutes long. And the nice thing is they're little webinars. So they're available anytime you want to listen to them, pass them on to friends or family. And a lot of the topics that we cover in our SRC University come from our book. And if anyone is interested in our book, you can either download it on our website, or you can ask Barb and we can get an address or mail them to the office. And we have hard copies of the book that are coming in at the end of this week. And we're happy to give those out for free. And our ultimate goal is to create a safe, secure retirement for people. And the good news about our school is there's no final exam. So that's nice. All right. So I'm going to have Bill touch on the difference between advisors and planners.
Sometimes people ask us, good morning, everybody. Thanks for joining us. Sometimes people ask, what the focus of our practice is at Senior Resource Center. And they often ask, are you a financial advisor? And we tell them, no, we're really financial planners. And kind of the difference between us and advisors help people review and select products. It might be picking a stock, bond, mutual fund to get growth on investments, or it might be a Medicare supplement or Advantage plan to pay for medical expenses in retirement. Advisors are very good at measuring performance. The focus they have is pretty much now. They can tell you where you're at. Within our practice, we do financial planning. And as Tara mentioned, we use powerful software to help our clients look into the future and see where they'll be 10, 15, 20, or 30 years into the future. And, what we found is people are living a lot longer. And since retirement's a lot longer, it exposes our savings to kind of a litany of risks. Could be fees, could be taxes, could be market corrections, could be scams. There's a lot of things that we have to confront. And so in our practice, we have to speak many languages to build these models. We have to understand Medicare, Social Security, probate, taxes, inflation. We have to include a number of factors to help our clients see where they're going to be down the road. And so our focus is on the future. We're kind of like mini time travelers. Quick disclosure, today's topic discusses legal documents. We aren't attorneys, but we've worked with elder law attorneys for 22 years. And through that process, we've learned a lot about the legal documents that help people plan ahead for while they're alive and after they pass. But if you have any real questions, specific questions on legal documents, you should refer those to a licensed attorney. So let's start out with the problem. And, the title of this talk is actually something that I'm somewhat uncomfortable with, estate planning. Because when people think of estate planning, often they think of people with huge, vast fortunes or rich and famous, and, they've got to plan out their estate. Well, what we're going to talk about today is for everybody. It's not for the rich and famous, it's for literally everybody, because we all have wishes that we want to protect. And estate planning is really a nice way of saying that we're going to protect our wishes through a series of generally legal documents. And in our world, estate planning is really fourth quarter planning. We're getting into our senior years, and we want to make sure that we can control and manage our savings as we get older. We also want to pass those hopefully privately and safely to the next generation. So a couple other aspects of estate planning. Unfortunately, death isn't optional. So all of us are going to have one. And when we do, there'll be a divvying up or a passing of assets after our death to heirs. And we've seen many, many situations where this can become very problematic. So today we're going to talk about ways to ensure that we don't go through some of the problems that we've seen other families have to go through. More and more, we see that usually incapacity precedes death. And my parents are a good example of it. My mom had a stroke when she was 82, and she made it 14 years, paralyzed, but perky. She was alert and bright, but perky in a wheelchair. And a year after mom had her stroke, Pop came down with Alzheimer's, and he made it 9 years. Well, they needed help making financial and medical decisions. And so with more and more people today getting dementia and Alzheimer's, we need to plan ahead for what happens if we can't make our own decisions. Many clients, our practice started back in 2002 with long-term care planning. And we'll touch on this briefly in this talk because this one's focused more on estate planning, but that ties into planning ahead for long-term care. You might have a blended family. My wife and I do, which means that can create some special situations. You might have a special needs child that'll need protection and support after you're gone. And so there's legal documents that can help make that much, much simpler. Finally, we'll touch on some tax consequences that you or your heirs may face. So here's the topics we're going to walk through. We'll introduce legal documents and show how they protect wishes. We'll focus on two types of legal documents, those while we're alive that are active, and then those that take over after we die. We'll touch on some special situations, and then as I mentioned, we'll talk about tax consequences in estate planning. Remember, Tara said there's no final exam. So this is a high-level view of what some of your options are. And if you have questions on this, you can always call us. Our consultations, our meetings are always free. We're happy to answer questions. So in our world, legal documents protect wishes, and we divide them into two main categories: the documents that operate while we're alive and those that take effect after we die. While we're alive, generally what people are worried about is incapacity. What if unfortunately, my brain gives out before my body does, and I need somebody to help make decisions for me. And in this scenario, we're trying to avoid guardianship. We'll talk a little bit more about this, but guardianship can be very expensive, very painful, something to be avoided. And then on the after death documents, generally we're talking about passing assets. And there the question is there a way to avoid probate? We'll talk about what probate is and how we can go about avoiding it. So on the living documents, let's say we're faced with a situation where there is incapacity. And, sometimes people say, well, what if I don't have the right documents? What if I have no documents? Well, then I'm going to be controlled under a process called guardianship. And that's where a local probate judge appoints a guardian to manage your affairs. And what's the problem with guardianship? Well, number one, it can be very, very expensive. The court costs associated with it, the cost associated with appointing an ad litem to help find someone who's going to serve as the guardian, that can be expensive. And with guardianship, you have to go back to the court annually and report back to the judge how you've spent all of that person's money. So you can imagine there's maybe a CPA involved, or maybe there's lawyers involved. It can be a very, very expensive process. Fortunately, there are two simple documents that take away all of the need for guardianship, and those are powers of attorney. These are documents that we'll go into a little bit more detail, but they help make financial and medical decisions so that if you can't manage your own affairs, someone else can manage your assets and help make healthcare decisions for you. So let's talk a little bit about a financial power of attorney. This is a document that's going to appoint somebody to manage your financial resources, to make financial decisions for you. We always recommend to our clients, when you complete a financial power of attorney, in fact, if you do any legal document, always do it in blue ink. People go, why? What's important about blue ink? You always want to be able to spot your original from a copy. A financial power of attorney is valid if it's an original, but copies, while some organizations will accept it, some won't. And so it's always, if you have a document that's been filled out and notarized in blue ink, you can, if you go to a bank and they say, can we make a copy of your power of attorney? You can always spot your original from a copy. Powers of attorney should name multiple agents that operate in serial, not in parallel. We've had people come in that have a financial power of attorney where they've named a son and a daughter as co-agents. Well, the problem with that is if you go to the bank and say, hey, I want to withdraw some money out of mom or dad's account, the bank is likely to say, well, where's the other co-agent? Well, they're traveling or they're incapacitated. They're out of the country. Well, we're not going to do anything today because we want both agents here to co-authorize this transaction, this withdrawal of funds. So we always recommend name multiple people, but the people should be operating serially, one at a time. So we appoint Tom. If Tom can't act, then we appoint Susie. If Susie can't act, we appoint Bill. We also recommend, and we'll touch on more of this later in the talk today, that the power of attorney should allow for broad gifting. That may sound kind of crazy. Why would I want to allow my agent to broadly gift? We do a lot of long-term care planning in our practice. And oftentimes working with single people, the only way to shield and preserve assets from long-term care expenses is to move money out of the person's control to a son or daughter to manage for them. But to make that transaction, you have to ensure that your power of attorney authorizes broad gifting. The second major document that we recommend, these are everybody documents. Everybody should have a financial power of attorney. Everybody should have a medical power of attorney. Why do I say everybody? Because we're all one accident or injury from needing someone else to step in and help make decisions for us. So these are not old person's documents. Everyone should have a financial and a medical power of attorney. Once again, fill it out in blue ink, and it can either be notarized or witnessed. Oftentimes, if people are getting both a medical and a financial power of attorney done at the same time, we go, hey, just get a notary, and they can notarize both documents at the same time. This document should also appoint multiple serial agents. So if the person you name as primary can't function or can't make decisions, medical decisions for you, that another agent has been appointed. A medical power of attorney only takes effect when you can't make your own decisions. So as long as I can talk to a doctor or a nurse and answer questions on my own behalf, the medical power of attorney doesn't step in. They only take effect and really serve when I can't make medical decisions for myself. In the state of Texas, a spouse can make medical decisions for the other spouse without a medical power of attorney. But a child cannot. So if you're single and you have some adult children and you become incapacitated, your kids may want to help doctors make decisions on what care you receive. But if they aren't authorized under a medical power of attorney, they don't have that authority. You can use the medical power of attorney to control or to limit decision making. You can give them broad medical decision making, or if you choose, you can limit it. Some of the other basic documents that we see, one of those is what's called a living will, or a directive to physicians and surrogates. And this living will, it's not a will actually, but it restricts two decisions that people want to make for themselves. One is, I've been told that, I have a dread disease. Do I want maximum therapy, or do I just want to be kept comfortable? Do I want maximum therapy, or do I want to be kept comfortable? That's a personal decision. By making it, it means your medical power of attorney doesn't have to make that decision. The second decision usually that a living will makes is, I have an irreversible condition. You may have remembered the lady Terri Schiavo who lived in Florida. She had a traumatic brain injury and was brain dead, but she was still alive. And her husband, after consulting with the doctors, wanted to unplug her, wanted to let her go because she wasn't going to come back. But because she hadn't signed a living will, in identifying her own needs, the doctors were reluctant to allow that to go forward. And it led to a big court confrontation where eventually he was granted the right to unplug his wife. Well, so the second one is, if I am brain dead, I'm not coming back, do I want to be kept alive, or do I want to allow the doctors to pull the plug? These are two decisions. Do I want max therapy or just be kept comfortable? And do I want to be kept alive, or do I want to be allowed to be unplugged? Those are decisions we usually don't want our medical power of attorney making. These are decisions we should make for ourselves. Another option is a do not resuscitate. It's a personal choice, but if your heart stops and the therapist or the emergency unit comes, do you want to be resuscitated or not? It's a personal choice. And then another document is a guardian appointment. If you were to go through guardianship, who would you want identified? In this case, you don't want a judge making the decision on guardianship. You want to appoint or announce who you would like to serve as your guardian. Now, these are just a few of the documents that are available to a living person. There's many others. So our purpose today is to give you a high-level view of this. Of all these documents, the medical and the financial power of attorney are the most critical. These are documents everyone should have, because without it, we're facing guardianship. So what about documents that take effect after death? And just like with the living documents, sometimes people don't plan ahead for this. So what if I have no documents? What if I haven't planned on how I want my personal savings and assets to be divvied up? Well, then I die essentially intestate. That means I die without some designation of where my assets are going to go. Fortunately, the state has a will for each one of us. If we haven't stated our own wishes, the state will distribute assets based on a state formula. This is something the legislature has put together, saying here's how we're going to divvy up assets. But it may well not be the distribution of assets that you're interested in. So for our clients, we talk to our clients about having either a will, a trust, or putting beneficiary designations on assets. And depending on which ones of these options you pick, you may go through a probate process or non-probate. So what is probate? If you die and have a will, you're going to go through probate. If you're using a will to distribute your assets after death, you're going to go through probate. Probate is a courtroom process. It's administered by a probate judge. Each county in Texas has a probate judge. And essentially the judge reads the will and then appoints an executor and tells the executor, here are letters of authority that allow you to distribute assets according to what's in the will. The downside of probate is it's a matter of public record, which means someone can go to county records and see who you gave money to, how much. And sometimes unscrupulous people use that public record for their own private gain. They'll solicit people or seek out people that have just inherited substantial assets. We prefer a non-probate process, and both trusts and beneficiary designations don't go through probate. But no matter which of these you select, you're maintaining personal control. You're identifying who's going to get what. So let's talk a little bit about wills. Wills are both witnessed and notarized. They name an executor. This is someone who's going to be appointed by the court and administer your will, the wishes defined in your will. As I mentioned, wills have to go through probate. And the downside of this is in most of the Texas courts today, judges, the probate judge will not let a son or daughter come in and self-probate their mom or dad's estate. For court efficiency, the courts now require, many of them do, that you bring in an attorney to take you through probate for court efficiency. Well, what's the downside of that? You're going to spend $2,000 or $3,000 in legal fees, getting an attorney involved, going down for court hearings, and going through the probate process. And we're not big fans of going through probate. Texas is not a probate unfriendly state. It's still fairly simple. If you were living up in one of the northern states like Pennsylvania, New Jersey, New York, there the joke is that probate is a lawyer's retirement plan, because often probate can take 2 years with multiple court hearings. So it can be very expensive, very lengthy. That's not true in Texas, but once again, if we can avoid it, let's avoid it. So a second option for passing assets is setting up a trust. And there are many types of trusts. There are revocable trusts and there are irrevocable trusts where you can't make changes after you've funded the trust. So what is a trust? A trust is essentially an empty box. It's a legal box that has a separate identity from the person who is setting it up. So if I set up a trust, initially there's nothing in the trust, and then I can deed into the trust some of my assets. I could put my home in the trust. I could put my bank account in the trust. I could put my brokerage account in the trust. So what's the advantage to putting assets in a trust? When the owner of the trust dies, the person that has funded it dies, the trust doesn't die. The trust doesn't have a time of death. The trust is merely a box holding assets with a set of rules. And it says when the original trustee or the grantor of the trust passes away, follow the following rules. Since the trust didn't die, there's no reason to go through probate. It's a private transaction. The trustee will then read the terms of the trust and honor them and distribute assets according to what the original trustee wishes were. So it's private. It's not in the public. It's not set for public scrutiny. So no one can tell how you gave away money and to whom you gave it. The good news about a will is they're not that expensive to set up. Typically think $1,000 or less. When you get into trusts, you're probably talking about $2,000 or $3,000 to set up a trust. Once again, prices vary based on the attorney you pick and the extent of what you're trying to accomplish. Trusts are effective in another regard. If you have property in multiple states or multiple counties, well, if you have a will-based plan, and let's say I have property in Burnett County, property in Williamson County, property in Travis County, you have to probate the property in the individual county where it exists. So if I have property in multiple counties, you're talking about a fairly extensive process of visiting multiple counties, going in and hiring an attorney to represent you in each one, and going through multiple probates essentially. With a trust, all of the assets, even if I had 3 properties in 3 separate counties, they're all handled under the terms of the trust. So you don't go through probate in multiple counties. It's all handled privately. The last option for passing assets after death is actually the simplest and the least expensive. And it's setting a beneficiary designation on each of the key assets that you have. So if you have a bank account, if you have a home, if you have a brokerage account, if you have an IRA, if you have vehicles, all of these we can put a beneficiary designation on so that they don't go through probate. Trusts and beneficiary designations don't go through probate. Also, beneficiary designations trump a will. So let's say I've named someone to receive my home as a beneficiary designation, but in my will, I name a different person to get all of my assets. Well, the beneficiary designation is going to take precedence. It's going to take priority. It happens first. And so whoever I name as a beneficiary is going to get the asset with no challenge, no dispute. Oftentimes you can name both a primary and a contingent beneficiary. Primary being, if I die, I give my home to my wife. But if she's not alive, I want it to go to my son and my daughter as contingent beneficiaries. And there's multiple ways to set up beneficiaries on financial assets to accomplish people's wishes. On a bank account, you can go to your bank and set up a POD or a TOD. What is that? They don't call them beneficiary designations. They call it a payable on death clause or a transfer on death clause. So on my bank account, I can name my son as my POD. So what's the advantage to that? Well, if I haven't named a beneficiary on my bank account and I die, the bank is going to freeze that account. They're going to lock up the funds until a probate court tells the bank who gets the money. And this can be real problematic if you're trying to pay bills and, pay funeral expenses, maintain a house. You may need access to those funds. So it's important to put a POD or a TOD on bank accounts. What about land or a home? These are generally assets that go through probate. Fortunately, in Texas, we have 2 options. On a home or on land, you can put either a ladybird deed or a transfer on death deed. And both of these deeds accomplish essentially the same result. Under the term of a ladybird deed or under the terms of a transfer on death deed, you own your home. If after deeding it this way, you decide, hey, I want to sell it, you can. You can live in it. You can lease it out. It's your home. You maintain your senior exemption if you're older than 65 on the property taxes. But what a ladybird deed and a transfer on death deed add that a traditional warranty deed doesn't offer, it's a beneficiary designation. It says when Bill dies, he wants to leave his house to his son and his daughter. And so they then become the owners of the house. So 2 different documents, both essentially accomplish transferring a home or land without going through probate. What about a vehicle? Well, in Texas, we have, fortunately, our Texas Department of Motor Vehicles allows us to put a beneficiary title on our vehicles. So once again, if I own a car and I've put a beneficiary title on it, I could sell it next week. I could give it to someone else. But if I die owning it, automatically the named beneficiary can go to Texas Department of Motor Vehicles and provide the death certificate and say, Bill has gone to heaven. It's time to convert ownership, and now ownership transfers to the named beneficiary. So once again, the vehicle doesn't have to go through probate. So by putting beneficiary designations on everything we own, we're not talking about personal property here. That should be handled with personal notes or records within the family. But on financial accounts, IRA accounts, brokerage accounts, CDs, money market accounts, land, homes, mineral rights. You can generally put a beneficiary designation that allows the asset to pass without going through probate. Two things that we've run into over the years that we strongly advise our clients to avoid. The first one is going to seem like a good idea, but it's a very bad idea. And that's adding a child's name on as a co-owner on an asset. So let's talk about a couple of examples of this. If you have a home in Texas, you have a homestead exemption. What that means is a creditor, a lawsuit can't get your home. It's your kingdom. They can't get it. But oftentimes people go, gee, I'd like to avoid probate on my home, so I'm going to add my son or my daughter's name onto the title, onto the deed. And that way it won't go through probate. That's true. What's the downside? The child doesn't have the homestead exemption. So, if you turn on TV today, the ads you see for Thomas J. Henry and Ted Lorenz and Daniel Stark, they're all about, hey, have you been injured by an accident? Well, we'll represent you and get a big judgment, a big settlement. So let's say you've added a son or daughter onto your home and they're driving down Mopac and have an accident and injure somebody or kill somebody. Thomas J. Henry's going to come back and get your house. And it's a back door that strips away the value of your home. You can actually lose your home to a creditor or lawsuit charged against your child. So we don't want to add a child on. Same thing is true of adding a child on to a bank account. We've had clients come in that go, I want to keep things simple. So I've added my daughter on to my checking account. I actually had a lady come and see us about 10 years ago. And she said, I have a problem. Can you help me? And I said, what's the problem? And she said, well, I added my daughter onto my bank account. Yes. I said, so what's the question? Well, my daughter went through a divorce and the soon to be ex-son-in-law named the bank account as community property. And he got half of what was in my checking account, even though all the money was mine. And so it was a sad situation. We couldn't help her. By adding on the daughter's name, she had exposed it to creditors, lawsuits, and in this case, to a divorce settlement that took half the money in mom's checking account. So if you're going to add a child on onto a bank account, add them on as a co-signer and as a beneficiary. So what's the advantage there? As a co-signer, they don't have any legal ownership of the asset. They can write checks, but they don't own it. So if they get sued, there's no claim against your bank account. Well, what about after you die? You also name them as a beneficiary. So once again, the bank account doesn't have to go through probate. But let's touch on a few special situations. We'll talk about blended families. I have one, a special needs child, and we'll touch on long-term care. Many people today have blended families. My wife and I do. I have 2 children. She has 3 children. So together we have a full house. And oftentimes, many of them are at the full house at home. They come home. But this can lead to some family dynamics. When someone passes away, it can be very interesting as to how kids that got along for a long, long time no longer get along so well. So in the case of a blended family, it's very, very important to have beneficiary designations, a will, or a trust, because family agreements on who's going to get what can get very muddied, very murky when you have kids, when someone's passed away and now there's a lot of money at stake being divvied up. Another factor on wills that is a reason we generally suggest not getting a will, or if you have, it's not that bad to have a will, but I would probably also then recommend having beneficiary designations, is because wills can go through disputes. And we've seen cases of where a child that's been estranged from a family for years, hasn't been a part of family life for years, and isn't named in a will can come back upon mom or dad's passing and go in front of the probate judge. And when the judge says, is there anyone here that contests or disputes this will? The hand goes up and they go, I've been estranged from the family. I'm the son, the prodigal son, and I've been away from mom and dad for years. But a week before mom's passing, we had a reunion and we resolved our differences. And in that family get together, mom said she wanted me to have half the estate. Well, the judge doesn't know what really took place in that meeting. And we know cases and situations where probate judges have ripped up wills and redistributed assets based on a good storyteller. So if you have a blended family, it's more important than anything to make sure you have the right legal documents spelling out who's going to get what and how. What about a special needs child? Today, it's unfortunate, but many families have a child that either has mental or physical complications, and the parents are worried, what happens when we're gone? Who's going to look after our special needs son or daughter? Fortunately, there's a simple document. It's called a special needs trust, and it isn't spawned or created until the trustee, the one setting up the trust that spawns it, dies. But what does the special needs trust do? It sets aside funds for the benefit of that disabled child. It ensures funds are available to support their quality of life. More importantly, it's designed in a way that it ensures continued access to federal and state benefits. Oftentimes, a special needs child might be receiving Medicaid benefits as part of their lifestyle. Well, receiving a large inheritance could disqualify them from federal or state benefits. We don't want that to happen. So with a special needs trust, you can set aside funds and appoint a trustee, probably another son or daughter, to administer the trust, use the funds to ensure the quality of life of the child that needs special care, but not preclude that child from also qualifying for federal and state benefits like Medicaid. The last special situation I'd like to touch on, and this can be an entire webinar on its own, is long-term care. This is where our practice started back in 2002. And we started out doing Medicaid planning for people in nursing homes. And we started out with a goal, and it's been our goal regarding long-term care all the way through, and that's to preserve assets. Probably the single greatest risk each of us face as we get older is paying for long-term care. We're living longer, but sooner or later, either our brains wear out or parts of our body wears out, and we need care. And unfortunately, with modern medicine, the length of care is going up. And because it's labor intensive, the cost of care is also going up, whether it's received at home, in independent living, in assisted living, in adult daycare, or in skilled nursing. Each of these has become more and more expensive. So within our practice, we focus on two federal programs that help pay for long-term care. And where does long-term care planning fit in? It's part of estate planning because we know most of us are going to need long-term care. If you turn 65 today in this country, you have a 2/3 chance of needing long-term care before you die. The notion of living long and not waking up some morning or having a heart attack isn't happening. People are waking up and they need care at home or in a facility. And the care is very expensive. So we've focused on two different federal programs. The VA program we focus on is called VA Aid and Attendance. And the benefit of it is it pays for care wherever you receive it, at home, in adult daycare, in assisted living, or in skilled nursing. To receive it, you have to be a wartime veteran, not in combat, but you have to have 90 days of active duty during a wartime period like Korea, Vietnam, or the Gulf Wars. Or you can be the spouse of a wartime veteran and receive benefits. And this benefit pays out a fixed tax-free monthly pension. So it can be very helpful in defraying the cost of long-term care being received at home. If you have questions on the VA program, call us. Happy to send you a brochure. If you get a copy of our book, there's a whole chapter in there that deals with long-term care, talking about VA benefits extensively, who's eligible, how much. And it talks about the second program we work with, which is Medicaid benefits. The difference between VA and Medicaid, Medicaid only applies to folks in a skilled nursing home. So you can't get VA benefit or Medicaid benefits in assisted living. You can get it at home, but it's like hen's teeth, very rare. So think of Medicaid as paying for skilled nursing, and VA is paying for care wherever you receive it. Within the Medicaid realm, there are two legal documents that come into play. If you have a home, you want to protect that home. And homes in Texas under Medicaid are exempt assets while we're alive, but they're recoverable Medicaid estate recovery after the person dies. So to avoid Medicaid estate recovery, or MERP, we want to put a ladybird deed on the house. Once again, you still own your house. You can live in it, sell it, lease it out. It's your house. But upon your death, it passes. Because you've named a beneficiary, the ladybird deed also avoids probate. The second major document that comes into play for Medicaid recipients, oftentimes people's gross monthly income is greater than the Medicaid limit. This year it's $2,829. So if my income is $3,000 a month, Medicaid says, well, you're above the limit. You're not eligible. Fortunately, there is a program that was created years ago. It was originally called a Miller Trust. Today it's called a Qualified Income Trust. It's nothing more than a glorified checking account that your income passes through on the way to the nursing home. And it allows people to get around the income limit for Medicaid. So these are two more legal documents that come into play that are very important in helping people qualify for Medicaid benefits. And within our practice, we also have a range of insurance products that we help clients investigate to help multiply their income or their savings to help defray the cost of long-term care. Once again, this is like drinking out of a fire hose snapshot. We do entire presentations on VA and Medicaid benefits. So if you have an aging relative, talk to Barbara and we can set up another presentation. Last but not least, I want to talk very briefly on tax consequences. Most of us won't have to worry about paying estate tax. Why is that? Well, the estate exemption this year, 2024, is $13,610,000 per individual. For most of us, we won't have an estate tax problem. But there is a way that we can take advantage of this while we're alive. People think, well, at my estate tax, I can only take advantage of that when I pass away and I transfer assets to the next generation. But in our practice, oftentimes when we're doing Medicaid planning for individuals, we use gifting as a strategy to preserve a portion of their gifted assets, to preserve assets, qualify them for Medicaid. This year, you can pass $18,000 tax-free to an individual without paying estate or gift tax. Well, if you want to gift more than $18,000 in a calendar year, you can tap and use part of your estate exemption. And we do that using what's called IRS Form 709. So just know that for most of us, estate taxes are not an issue, but if we want to gift more than $18,000 to a son or daughter, we can do it without paying gift tax. There's other different types of assets we have after we die. If you have a home, land, or after-tax financial accounts, like a checking account, a brokerage account, money markets, CDs, those get what is known as a step up in basis. Let's say I bought my home for $300,000, and when I die, it's worth $500,000. Well, the named beneficiary, or the people that get that home, don't pay any long-term capital gains on that. They get a step up in basis. So they inherit it at $500,000, and if they sell it the next week, they'd owe no tax to Uncle Sam. That's pretty nice. It's nice to have a step up in basis. What about qualified accounts? There is no step up in basis on 401ks, IRAs, 403bs, Roth accounts. There is no step up in basis. On those accounts, you can pass them to the next generation. But a major change that took place back during the Trump administration, today when people inherit, when a son or daughter inherits a qualified account, they have to withdraw all the funds within a 10-year period. Why is this a problem? Oftentimes, kids are in their peak earning years when you go to heaven. And by adding on additional withdrawals from IRAs or 401ks, it can push them into a higher tax bracket and make Uncle Sam your primary heir. So our goal in helping people with estate planning is plan ahead so that we don't see Uncle Sam become your primary beneficiary. Wow, that's a lot to cover in a very short period of time. And we like to really, the total title here is Plan Your Estate. But for most of us, we want to leave a legacy. And we work with our clients to help them map out who they'd like the asset to go to so they can be remembered after they go to heaven. And we help our clients accomplish that. So if you have questions about what we've talked about today, or I think when Barbara sent out this invitation, she mentioned we do talks on many topics: Social Security, maximizing it, making Medicare choices, how to pay less taxes, how to maximize the value of your retirement account. There's many topics we talk on. I'm happy to come back at any time and share additional educational topics with you. So with that, Barbara, I'm going to turn it back to you. If there's any questions, we'll do our best to answer them.
Yes, thank you so much, Bill. That was very useful information and very informative. And we do have some really good questions, and we are planning to have you back. We're hoping to do kind of a whole series. The first thing that we have is that somebody would like to get a hard copy of your book, and where would they get that?
Send an email to one of the three of us, Bill, Bill, Tara, Tara, or Stacy, Staci. If you send it to Bill at SRC, standing for Senior Resource Center, Texas, it's on the bottom of the screen. Send an email to any one of us, and we're happy to mail out a copy of the book free of charge. We didn't write it. We sell it up on Amazon, but we give away the book, and every year I get like $3 worth of royalties on the sale of the book. So our goal is to educate, not to make money selling the book, but it explains all the topics that we help with in our practice.
Wonderful. And then we have a question, and this was from earlier in the presentation when you were talking about medical powers of attorney and living wills. And it said, should we be putting those requests in a living will, or can we have our medical power of attorney make those decisions if we've discussed them prior? So meaning what your wishes are for your care, the living will type of stuff. Do you have to have the living will, or can your medical power of attorney make those decisions if they've had a discussion?
You could build it in, because within the medical power of attorney, there's a section that says, if you would like to limit or control medical decisions, explain here. And then there's some blank lines. So you could write in there, if I am terminally ill, I want maximum therapy. So you've pre-made the decision for your power of attorney. They can't override that. You've already stipulated, I want to be kept comfortable, or I want maximum therapy. Or if I'm on life support, do I want to be unplugged, or do I want to be kept alive? That's a personal choice. You could build it in. Usually people have a separate living will that explains those two decisions, but you could combine them both into medical.
Okay. And then when a person does not have a will, what is the benefit to having a lawyer represent you?
Well, if you don't have a will, you've died intestate. So if you have assets that don't have a beneficiary designation on them, you're now going to go into a probate court, and your estate is going to go through essentially intestate. It's going to be processed and divvied up according to how the state legislature has defined a will for someone who doesn't have a will. And it would, identify who the heirs are and what percentages they get. And it could be children, cousins. There you'd want to have an attorney involved to help sort that out and help guide you, because number one, the probate judge is going to want you to have an attorney there, but you'd also, there you're kind of at the mercy of the court, and you'd want to make sure that the court is applying their rules correctly. But far better, either have beneficiary designations on each critical asset, each account or major asset like land or a home or car, or have beneficiary designations on it. I mean, have beneficiary designations or have a will. To die without a will is creating problems for the next generation. It just makes the entire process more difficult.
I've lived through that with some people, some friends of ours. The husband/father passed away, and because neither there was no will and the children were both they were no longer minors, it created a whole situation for them to have to navigate through, because they were, I guess, technically by the state entitled to half or something. It was a mess, and they did have to have a lawyer to try and help them figure it out. So I think that's important. And I actually had a question. Even if you don't feel that you have any assets, would you agree, or maybe there's a different document though, that it's important to have a will if you have minor children that would designate what your wishes are for their care should you, die before they're no longer minors? Or is that a different document?
That's more of a lawyer question. I think if you want to pre-plan for what if I die early and I have younger kids, you more than likely, there's documents that can identify who you would like to have take care of your kids. And I think, that'd be valuable to have, because otherwise a judge is going to have to make that decision, and you're not there to state what your wishes are as to who you think would be best served to provide that care and that guidance. So that's outside really the scope of a will. A will is more intended to pass assets, but there are planning documents that tell the judge, hey, if I'm not around, here's who I think it'd be best served to raise my son or my daughter after I'm gone.
Wonderful. Next question. Do you need a will or trust if you have designated a beneficiary? Are there benefits to a trust in that case?
Well, beneficiaries trump everything. So if you put a beneficiary on every major asset you have, we're not talking personal property here. If you have china, silver, clothing, equipment, tools, those things can be divvied up with family notes or records. But when you have bank accounts, life insurance, a brokerage account, IRA, annuity, any kind of a financial account, or if you have real property like land or a home, there you're going to want to put a beneficiary on each item. I prefer that over a trust is more expensive to set up. I prefer that over a trust. But once again, everybody's situation is different. Our job is not to say get a trust or get a beneficiary designation. It's to sit with the family and go, what are you trying to accomplish? What is your goal? Here are your options. We'll help you kind of sort out which one might be best for your situation. And we don't draft the documents because we're not attorneys, but we help our clients try to understand, here are the risks you face if you don't have the right documents in place. And the most critical to me, over far and away, because we do a lot of long-term care planning, are medical and financial powers of attorney. Oftentimes people don't get around to doing those. And then a mom or son or daughter comes and sees us and said, can you get mom on Medicaid? And I go, yeah. Are you her power of attorney? She didn't get around to that. Does she still know you? No, she's beyond knowing me. Well, now we have a real problem. Now the only option really is guardianship. And that ties our hands, because a probate judge determines what's going to be done with the assets. And generally they're going to get flushed down at the care facility, spent down. So I like that. What's the downside of beneficiary designations? You have to manage them. If you have 4 accounts, a checking account, savings account, brokerage account, and IRA, and you put a different beneficiary designation on each one, and you have a falling out with the person that you've named, you have to go back and change it. So you have to keep track of who you've appointed as the beneficiary. If you have a falling out, or if that person has passed away, you want to make sure you go back and update your beneficiary designation.
And to that point, in my line of work, I've had to file a handful of life insurance claims over the last few decades for employees that have passed. And one of the ones that I've even shared in my presentations, encouraging people to make sure your beneficiaries stay up to date, is I had a man pass away and he had divorced and remarried like several years ago when he had passed, and he never updated his beneficiary on his life insurance with us from his first wife. And the second wife was not happy. And we had to deal with all of that. And there was nothing. I mean, literally, there was nothing they could do. So that's always my spiel. Like, make sure you review who you have your beneficiaries as from time to time, because if you forget about it, that's not the thing we think about every day, and we need to think about it, I don't know, at least once a year.
Well, I think in line with that, the other recommendation we make to everybody is, do you have an inventory of all of your primary assets? I mean, we all know where we have money. We have money in the bank or with a company, but our kids may not know that, and they may not know what the
Exactly.
account number is, how to access it. And if we have a beneficiary on my bank account, who is it? So if you maintain an inventory, it makes our job much easier when a son or daughter comes and says, can you get mom on Medicaid? Because my first question is, what does mom have? We don't know. Mom and dad were real private. Dad passed away suddenly a year ago, and now mom has dementia. She can't tell us. Now we have a real problem, because getting on Medicaid, we have to know what the assets are so that we can preserve them and use them wisely. So building an inventory, it may sound simple, but just writing down all of your assets by account number, who the custodian is, and who the beneficiary is, makes it much easier for the people that come later.
That's very good advice. My parents have actually done that, and we feel very grateful for that, actually. Next question: does the living will or will/trust allow you to make decisions about your parents' medical and financial needs? I thought there was a document will that would allow my sister and I to take care of those things as well as any property. I just can't remember the exact name of it.
Well, there you want to manage assets or accounts, financial accounts. You want a financial power of attorney that authorizes the named agent to act on behalf of the person named. If give me a good example. If your mom has a life insurance policy or dad has a life insurance policy, and you call up as the son or daughter, the life insurance company is not going to talk to you. They're going to go, you're not the owner of this policy. But if you provide them with a financial power of attorney, now they will answer questions like, what's the death benefit? Who's named as beneficiary? Is there any cash value? So for financial assets and managing finances, you want to have a financial power of attorney to represent someone. For medical decisions, you want to have a separate medical power of attorney, 2 separate documents.
Very good. Okay, I think that's the last of our questions. Lisa Brown Valadez was kind enough to put a link to your website in the chat for anybody who wants to grab that. And then you guys are getting just wonderful kudos here. I've got excellent, thank you, excellent, outstanding and enlightening, great presentation. This one I love. Wow, they should teach all this stuff in school. I'm so overwhelmed. Thank you for the topic, very informative. I mean, it goes on and on. Awesome presentation, very, very helpful. And I agree wholeheartedly, and I'm actually very glad that we recorded it because I feel like I kind of need to listen to it again. And I've actually kind of worked at least touching this space for 30 years. So it's even listening to all of it now with my parents aging, and then thinking of our children as well. And I think it's relevant to everybody, even if you don't think it's relevant today. I feel like it is. So I'm going to listen to it again.
Good. Well, we appreciate the opportunity. We appreciate the attaboys. Thank you. If people have questions, have them call us, get a copy of the book. If they have questions, happy to answer questions all the time. Just people need, as you said, Barbara, there isn't good education available. When we're in school, we learn geography and history and math, but we don't learn about retirement planning, and we don't learn about estate planning. And we feel it's our mission, first and foremost, to educate so that people understand they have choices and what the implications of those choices are.
Very good. I'm so glad we did this, and everyone in attendance, you can look forward to future presentations from the Senior Resource Center folks, because I think they've got more that could benefit everybody. So we really do appreciate y'all. Thank you so much.
All right. Have a good day and stay cool.
Same to you.
All right. Bye-bye.
Bye.